Yes.
Today was a maybe has some personal difficulty. Very intuitive to me. So regarding item number 37, 54, and 55, already states these methods may kindly taken up on Tuesday. And regarding other methods,
see, dear, I think item number, according to me, item number 4.
Yes.
Yes. Then item number 8, item number 9, item number 10.
Yes.
Thereafter,
58 plus 59.
58, 59, and then 37.
37 plus 54 plus 59.
54, 55. So what about the others? You are supposed to address others as already addressed, Mr.
In some cases, if any report is required to be I will again.
Okay, you have it. You have informed the others, no?
Regarding
basically, Mr. Bora has argued on the law point. Okay, then.
37, 54, and 55 may kindly be fixed on Tuesday. And regarding other methods like petitions here, it might not be.
Okay. We'll call the matter. You just when matter is called, we'll adjourn. Yes. We'll call, instead of passing the order now, yes, we'll accommodate it. No problem on that. Yes. Item number. This case, I think 161 statements are not there. Though scan copies were called for, 2 FIRs by 2 doctors, do not think it's a case of 376. But the problem is that scan copies, CD 161s are not there. I think that will require. You wait, we'll pass an order. Do you understand what I have said? Okay. Yes. Yes. Any interim?
Yes.
When?
On
6/10 update for update case interim to continue. Yes. You are for a petitioner. What is the matter about? NI Act. You are for the petitioner. You have taken consent.
Yes, sir.
Okay. As agreed to by the learned counsel for the parties. Business matter. After? When? Today is the convenient day for us. Mostly? September, October, no problem. 22nd of September.
Okay.
Yes. In 2017. What is the matter about?
We recently ordered.
Okay. As agreed to with the learned counsel for the petition. Matter stands adjourned for 3 weeks. Yes, next. No, sorry. Yes. Yes, Bhattagur.
Yes, no, item number 18, yes, there is not available.
In interim,
He's on it, 610.
610, interim to continue.
Item one, motion BA.
Yes, but what is this case? It's a case of passing. To the satisfaction of CGM Kamrup Metro 25.
Item two,
We'll call for case there in this case. Even early to
First of September.
1st of September 2020.
item three,
We'll call a CD here,
1 3.
119.
so motion item number four,
Supermetric on Tuesday,
29.
on the prayer of the learned additional public secretary, Mr. Okay, Tuesday we might have a problem. So Tuesday is what is the day? Date 29. And what will be the confident day? First.
Yes.
First. Inform him.
Item number five,
Papa? Oh,
item six,
no, it our DBS, no? Now, a request for the petitioner on call, next week.
item six,
Okay, so
Yes, training of child.
nothing is there. It's a case of passing. None appears for the petitioner on call, please next week.
item number seven,
They are married. Only last ground is that he's not giving me the status of wife. Can it be 276? Yes. What codes? Now what to do?
My only prayer, my lord, there maybe is, I have already advised my client.
Yes.
Some settlement. So,
Do one thing, where today is 24th. We are taking it on Friday. Have an instruction that whether he will.
but already I have instructed. My
Yes.
only prayer, my lord, that she will kindly admit them letter, my lord. Within a very short time, my lord, we will. Because it is only 1 lakh of it.
That is what we have seen. Can anything be deposited for the stay, say 25,000 at least?
But, as per the rule, my lord, 20%.
Twen- Okay, that's why
20% will give.
20% admit. In the decision application under so and so admit call for the, we are issuing notice for the party. Notice, returnable effect for 4 weeks. Bothakur is a party,
Yes, I will.
except Bothakur accepts. In IA Vivo, issue notice returnable on the same date. As an ad interim measure, subject to deposit of 20% of the compensation amount. Compensation is 1 lakh. 20%, subject to deposit of 20,000. The impugned sentence shall remain suspended. Hmm.
So otherwise, he has to go to jail.
Okay, so you're saying it. So sentence will call.
Will he be allowed to remain on either of the-
Okay, subject to deposit of aforesaid amount, 20,000, subject to deposit of 20,000, the petitioner is allowed to remain on previous bail, subject to deposit of the aforesaid amount within a period of, within a period of 6 weeks, by the returnable date, returnable on 6 weeks, by the returnable date, the petitioner is allowed to remain on previous bail.
Item 58 for motion supplementary list.
Report not yet received.
On when, Muslimi, first of September,
Yesterday, I think it's not today. So yes.
we have fixed this method for today for some other purposes. That purpose is already postponed to 1st of November. That's why we are fixing it 1st of September. So we are fixing it on 1st of September. In the meantime, Lord Thakur shall obtain a report from the investigating officer.
That's a comment. 9 months pending notice has not yet filed.
So you want right now the Zimma without hearing them, without having a report from police.
59,
On first you have a report. You have the report. In some cases, these are not non-issues. We'll individually allow it. But so far relating to the state's appeal, we'll have to deliver something. So we'll pass separate orders on first. Like we have already allowed many cases, most of the cases we'll allow with those conditions. But in the state's appeal, well, additional advocate general will argue, here certain law points are involved, we'll answer it separately. In the case of the state,
Otherwise, in this case, I will try to get.
you get the thing, and these are, we'll treat it to be individual cases.
Yes, sir.
We have already passed some orders with certain conditions. So even if suppose 451 or 457, we do not go into the thing, 482, looking into the report and entirety, we will pass the order.
bail hearing BA, item 11.
Item,
11.
bail hearing. Most probably people are thinking that I am in DB. DB is at 3:30. BA for how many days? What is the method in sheet?
Otherwise, matter is some ATM matter, what they have done, madam, why it is passing, madam, he includes some money, 20,000 money.
How many days they are inside? Let us wait for some time. Since CD has come, material is again. Okay, so that's why. Okay, next.
Bail hearing item 13.
FR is submitted that this is AB, huh? That the police has already filed final report in this case, closing the investigation being true. FR
FR number 83523.
Hmm.
That is 17,523.
in view of the
835/23. That is 17,523.
in view of the above, nothing survives in this anticipatory bail application. Accordingly, the same stands closed. In connection with this,
This could be a case number 4192.
Item 14.
disposed of. Yes, Parasa, item 14. What is about item 14?
There are two cases. One is Gandhi case number 114/2012.
Hmm.
In that case, FR, in FR number 68/23.
Hmm.
That is 24.
This is a case under 438 for Sohrab Ali and Moinul Islam Hailakandi police case number 114 of 2012 under 120B 460-34. FR.
Actually, earlier, by mistake, just earlier stated of 2022 we have did.
Okay.
And that is also, but now in 11412, in FR, right, FR number 68 of the 23,
Hmm.
that is 24/4/23.
Okay.
And in connection is case number 11,
Where is item number?
no, same, there are two cases, man.
Okay.
Two cases also.
Okay. And in case of
112 of the 2012,
Hmm.
that is here. Right, subject number.
they are accused. These persons are accused in that case.
Yes, it's one of
So there are two cases against these petitioners. One ended in final report.
Yes.
112 of 2012 and other 114 of 2012 ended in FR and 112 2012
that is,
that is charged. These are the people charged. Any bail
no,
in
yeah, actually, both the city council, but perhaps this is one of two is cross.
That's why should we do all this of exercise when the petitioner is not present?
One of, he is speaking well in 114.
Ah,
In that case,
okay. So here 112 will see only FR. Okay. FR. Opposite order, the learned additional public prosecutor, Mr. Parasar, submits that the police has submitted final report after investigation in connection with Hailakandi PS station case number 114/2012 under section registered under section 120B/468/34 IPC. Wherein the petitioner are seeking anticipatory bail. Full stop. In view of submission of final report, nothing survives to be adjudicated in this bail application and anticipatory bail application. Accordingly, the bail application stands closed or it's closed being infractuous.
Item number 15,
It will order. This one, huh? It will kind of education bill. Item number Yes. Is in interim.
yes.
Okay. When?
Statement of one different
What is this IA criminal? Okay. 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 That's not an issue. Then what? There are two petitioners.
Petition number 3 statement recorded, but statement of petition for 1 and 2 not given.
So what to do? You
But my instruction is to record.
okay? The up-to-date CD as called for is not received. Accordingly, the case diary be returned back to the IO for updating the same. Full stop. Mr. Mannan, learned counsel for the petitioner, submits that statement of all the petitioners has already been recorded. Full stop. Be that as it may, the updated case diary be produced on 18th of September 2023. In the meantime, the interim order passed earlier shall continue.
item 16,
Some problem. Here is a misunderstanding, I think. Yes, madam.
Here, speaking of this, earlier, there is a report that Swiggy was lying in the before the additional citizen to come metro. Now, this is of June. Normally, we have said 4 times in equation, but today no information. I have taken instruction whether any instruction will after some.
After some, or we'll ask the IO to be present.
Well, 4 times we have.
Yes.
17,
Presenting our last year.
None appears for the petitioner on call. It is submitted that the search sheet being the investigation has been completed and search sheet has been filed being CS number
172/23, that is 306,
in connection with case number
in connection with, Dubai case number 140.
2023. In that view of the matter, the present bail application is closed with a liberty, with a direction to the petitioner to appear so and so before the trial court until such decision or application, the interim order passed earlier by this court dated so and so, which shall continue. I will take
19.
it to continue. Huh?
Item 19.
Around 95 cases already taken after completion.
19 and 20 after.
Item 21.
Did you receive in this matter?
Yes.
The matter is that the prime accused, he was the driver of the truck. The carrier of 800 bags of cigarettes, and in the application also, he has stated that he has.
But nobody is here. None appears for the petitioner on call. Is this case diary is there? Okay, wait for some time. Otherwise, you'll pass the order.
22.
Should you receive? Yes. Where is the affair? Yes, what is her statement? Yes, Argo. What is your case?
In this case, you have to as per allegation of the conduct. But what is the inform at least 18
What is your age? No, what is your age? 25 years. And the girl is more than 10 years younger to you. And she has stated that you have forcefully taken her. That's the end of the matter. The statement has specifically, the victim has specifically implicated from the perusal of the case diary. It is clear that the victim is minor and she has directly implicated the accused person, that she has forcefully been taken away. So forcefully be taken away, and the forcefully taken away. Considering the direct role of the petitioner in kidnapping the minor girl and having sexual intercourse with her. This court thinks that this is not a fit case for grant of pre-arrest bail. Accordingly, the stands rejected. Any interim order? No. Yes, that is returned back.
Apply.
Item 23,
Option, judge of the division stated of the after some.
Yes, After item 23, after some time. Yes.
24,
Traffic submitted.
Same savings, yes, number.
Number 158 to 2023, dated 21/05/2020.
No interim. No? So last opinion on the appear before the court. Consider as per law. Last per line to that interim order will continue, that will not be there.
for orders, item 25,
Well, hearing police.
এই তিনটা আমার ক্লাস হবে স্কিপ করে দাও Orders,
Yes, sir, there is a report for from our area.
Hmm.
Regarding NDPS case, already he has completed the sentence.
Already completed the sentence. This was jail appeal. Who was amicus?
Ten years, 1 month, 7 days. 10 years is the conviction order.
Already released on 21/8. Okay. The learned public, additional public prosecutor submitted on the basis of a report of the superintendent of district jail Golaghat that the accused appellant has already been released from jail after completion of the substantive sentence, after getting the remission, including the remission earned, and the appellant was released from the jail on 21/8/2023. Full stop. In view of the aforesaid, this appeal stands closed. The report of the superintendent of district jail Golaghat is kept of record and marked as document and be marked as document X.
26,
Finally, only is not delayed by 132 days.
This is an application for condonation of delay of 132 days in preferring the connected revision petition. Okay. Criminal revision petition, issue notice returnable. Issue notice returnable after 6 days, petitioner to take steps in a period of 5 days by voters.
item 27,
Others-
Yes, please.
others- hmm?
Chief Justice IAS
Ah,
for condonation of delay or
Hmm.
filing a criminal revision lawsuit against the appellate order started by the.
how many days delay?
207 days.
First time?
Lawsuit.
Yes, notice 6 weeks, both ways.
I apply.
But BJP has accept notice to do. State is a party?
Yes.
And any other party?
Other body or
Exponent number?
But it's the information.
Implement is there to issue the text steps.
Hello.
standing item number 11, 11,
What is the elevation? Is that
One thing I want to point out, page 16.
yes?
He has been given a practical matter. Third paragraph, the perusal of the material record, it says, the include the complaint of injury like take that. Moreover, on his visual identification, it seems to be injured on his face.
What is the stage of investigation?
Investigation is going on, madam, regarding other, madam, other persons are also involved, madam. And here, madam, regarding death injury, and what of the IO is available, madam. প্রকাশ থাকে যে মৌতিমার ঘৰত উপস্থিত হৈ after মানে verifying the CCTV footage, madam, তেওঁক মাত দি ঘৰৰ বাহিৰলৈ আহিবলৈ নিৰ্দেশ দিয়া হয় যদিও প্ৰায় 20 মিনিট সময় কোনো মাত বোল নকৰাকৈ থাকে। তাৰপিছত অৰ্থাৎ ঘৰটো খিৰিকী খুলি লোক এজন দৌৰিব ধৰা মোৰ লগত যোৱা সংগীসকলে প্ৰায় আধা কিলোমিটাৰ খেদি গৈ লোকজনক কৰায়ত্ব কৰে। লোকজনক কৰায়ত্ব কৰাৰ সময়ত তেওঁ বাওঁ চকুত আঘাত পায়। পিছত উক্ত লোকজনে পদকীয় নুৰুদ্দিন খান ৰূপে বুলি
Then what is the first medical report? Immediately after arrest, you might have produced him before the police, before the investigating authority, or before the doctor. What that says?
regarding death medical report. But at the time-
Whether that injury must be there on the first day itself.
Yes, at the time of appearance on,
He fell down or whatsoever.
medical report is not available.
Let him go 24 days. To the satisfaction of CJM Kamrut.
And detail.
Otherwise, these offenses are continuously serious offenses.
No, it's serious, but problem is that offenses are 24 days, you have given custody. Magistrate says you interrogate him inside the, everything is given 24 days, enough time for you to interrogate him. You have interrogated him, what more you require?
Because not only, this is not an act of one single person. Because
Understand, you have interrogated him, he might have said something or he might not have said something. And custodial, your custody is not refused by the magistrate and said that you do. Have you done any interrogation in the jail? Tell us.
Otherwise, his statement is available.
No, he admitted his interrogation is done. For further interrogation, you have been given a chance to do in jail, whether you have done that. You have not done that, what is the meaning of keeping him? And I'm sure that you have not done that in the jail.
Only on the ground of length of the.
Length of detention. Yes, on the length of detention.
Item 16. Can we item 16?
Non-appears for the petitioner on call, list this matter.
16 months case diary also not available.
Case diary, non-appears for the petitioner on call. The case diary call for is also not available. Accordingly, let this matter be listed on
On 12/9.
12/9 for production of case diary. Any interim? No. No. I do not think any interim is there. No. But there is an order. Okay, no interim. Have the instruction whether he has already been arrested.
Item 19.
Whatever. Might be, that might be the reason. Yes, Kolita.
The case is 79 and 211. Prosecution and the FIR case 12.
Can't relieve articles.
They are in the FIR.
Yes.
1 month before critical.
Case 10.
FIR is against one Pranjal Mondal.
Hmm.
One
Page
12.
page 11, 12, yes.
আমি নপুষি যাও ও নপুষি সরকার গৌরবকে জানিয়ে দেওয়া 28/6/2023 তারিখে বানপানীর সময়ত দিয়া সাহায্যৰ ওপৰত উল্লেখ কৰা আগামী জন্য আন্ডাৰৰ বিৰুদ্ধে বিক্ৰী কৰিছে পিছত আমি ৰাজ্যৰ লিখিত অভিযোগৰ ভিত্তিত বানপানী ভিডিঅ' ৰেকৰ্ডিঙৰ জৰিয়তে উদ্ধাৰ কৰিলো পিছত আমি যোৱা 30/6/2023 ইংৰাজী তাৰিখত কলকাতা ৰাজতন্ত্ৰ বিষয়ানীক অবগত করো আর উদ্ধার করা মার্জিন সমঝাই দেওয়ার পিছনে আমরা এখন নিশ্চিত দিই ইন দিস কানেকশন ম্যাডাম
Who are you?
I am ম্যাডাম Shyamal Roy.
What is your relation with this Mondal?
Kindly come to case 14. sir. Case 14 ম্যাডাম in this connection 4 persons were arrested. This is a forwarding report. Proceed to find the name of the forwarded person. Case 15.
Yes,
Pranjal Mondal was arrested. Sahanur Alam, Wajid Ali, and Nurjamal Khan. These 4 persons were arrested. Nothing coming.
name and address, person Pransal Mondal arrested, Sahanur Alam, Wajid Ali,
Nurjamal.
Noor Jamal.
These 4 persons were arrested.
Yes.
Even then, nothing has come.
Why are you apprehending them?
I have purchased them 25 bags, 1 bag, 25 kg of rice from one Wajid Ali. Sahanur Alam.
Why you purchase?
Whether these rice.
Why you purchase? It's a material for the flood victims.
But FIR itself says that everything was recovered. So whether these 25 kg amount needs for the really was.
Yes. His case is that if everything is recovered, how can I purchase? But this is not the flood relief because you have recovered everything. But where is the CD says? But whether interim absolute considering cooperation and material available. Ali gitu di semua. Ali smita kata ini.
Okay.
20.
And who are you? Same purchase. Huh?
No, regarding of this, this petitioner report, Lordship,
Hmm.
he does business in step.
Okay.
Now.
Why 19 and 20 given together? Okay. Same CD.
Actually, I was in.
Oh, okay. You are doing that. Okay.
Now, one of the kids came, many kids came to his shop for generating e-way
Hmm.
for those student step.
Hmm.
He should.
How these people are issuing e-way bill? Tell us.
No, he said he's one. The owner of the shop. Subsequently, they came to know that those were stolen property.
So he can be interim absolute considering an interim. And cooperation. At least in dispose of.
Item 21.
Yes, what happened to Priyana Talukdar? Yes, it is there. But did he do?
Admittedly, he is the driver.
Driver, there is no dispute on that.
And even in the paragraph number 14 itself stated that he has taken
He sold it.
investigation.
He sold it to whom?
Not solely. He stated that in the paragraph number 2 of the petition, where is it?
Yes. No, where is the CD?
CD,
What the CD says, case diary says.
there are 800 bags of cement.
That is no issue on that.
And
He was a driver, where somebody might have, on gunpoint have taken the truck. Many things might happen. He may sold it out. What is the city says?
investigation is going on.
No, something is. What is his statement before the police? No, he's not, no interim order. Not even the whole cements, only 448 bags were missing.
The chemical that was provided.
Now, what is your explanation?
Well, I had explained this,
Tell us.
but he was on the video.
Hmm.
I'm not mistaken.
Hmm.
And some, someone was doing something.
No. What is your statement? Tell us. Gunpoint word I have used. Have you used that word?
No.
Okay. That's why you tell us what is your
There
pleading.
some alteration was there. Some
Hmm.
unknown person. They needed money, but you are like unconscious. And there are people.
He was unconscious. Where was he found?
They never do found some.
What is your explanation? Tell us. Suppose you became unconscious, then what happened thereafter? Somebody might have found you, taken to hospital, or you yourself regain consciousness. Then then what did you do? Ultimately, you regain your consciousness. Then what did you do thereafter?
Thereafter he searched for the vehicle.
Okay, fine. Then
Then when he came back.
came back to who?
The owner, he had informed the owner.
What is the statement of the owner?
But owner, supplemental owner, it was there.
The owner lost the FIR on 18/7/2023. What is the date you became unconscious? Hmm?
6-7.
6/7. When you met the owner? Hmm? So according to you, in the FIR, according to the FIR, there is no allegation against the driver. But you are saying that even after I came back to my owner, he lost the FIR. Then he would have said that my driver has told this is the story. What is the reason, motive of your owner who has not even alleged your name to say,
They have claimed that 800.
huh?
Whereas the vehicle claimed only 400.
Give me the CD. What is the statement of the owner?
Like what? The vehicle claimed 400. How is it 800?
So according to you, somebody,
Yes.
they have not touched any bags. Only if they made you unconscious.
But if
Because their happiness was to make you unconscious. They had no other object. So that you become unconscious, that is the problem. You will have to give a story. At least there is some link between. First, you will say that if it would have been your story, yes, there are 800 bags. They did this and 400 bags taken away. Thereafter, I was made unconscious. I came back to my owner on such and such date, which date should be subsequent to 18. It cannot be prior to 18.
Yes, the motive he could have made out experience. But you have that 800 back how you only the carrying capacity was 400 back. And the owner is claiming that 800 back. amount would be 300. How much that is?
So you are the only person in the vehicle, no assistant, handyman or anything. Let us give him interim protection and you have a updated CD. Everything will come up. Hard. So and so. Learned counsel for the petitioner also have Mr. Counsel. Learned edition in public prosecutor. Here is the case diary. Learned edition in public prosecutor submits that for proper determination, an updated case diary shall be required. Full stop. Considering the fact that no specific allegation has been leveled against the petitioner in the FIR as well as in the statement of the owner, full stop. Statement of the owner. This court is of the view that in the meantime, the statement of the driver be recorded for proper investigation. Full stop. Accordingly, it is provided that the petitioner shall appear before the IO within a period of 10 days from today to record his statement. Stop video in the event arrest, interim protection. Let us see, there may be some other reason also. He might be right. If the owner might have been claiming some insurance and all. The case diary be returned to the IO. 28.
Item 23.
Yes. Yes. Case diary received whatever. FR 9. Where is the original? Huh? What is this whatever? What is in the CD?
The case diary actually main allegation is against the person. There is one video footage is also available. And as per most of the IO and other statement. And case number 1, Dinapuri DB. She was already granted bail medal. And her statement is also available. He is the second wife of the medal informant. Initially, there is some dispute between the husband and wife. And thereafter, when she launched against his brother. And thereafter, out of compromise, initially, as per her spoken, as per her statement, initially excused her, and thereafter that case withdrawn because of their misunderstanding between the parties. Thereafter, again, his brother committed the offense. Thereafter, she launched again one case. And thereafter, in within that, all these persons, accused persons, trying to compromise the matter and took an initially for first case 35,000, and now for the second case demanded 1,50,000. And as per one video footage, this, he took in the first case, took an amount of rupees 30,000 and 10,000 from given to her.
Now, who is he?
He is along with all these accused persons. He was also Tire One was also there. So mainly allegation against this.
It is, so we can give him.
Yes. He was also there.
Okay. AB. His statement is not recorded as it. Okay. Huh? No interim. AB. Considering the material available on record. And the allegation in the petitioner, this court is of the view that no custodial intervention is necessary. However, however, it is provided not accordingly release granted with the following condition: he will appear before the IO within 10 days. But the condition will be given.
For Poshman, item 28.
Who is for the other side?
In this case, lordship, there is no case diary. Here, that's wrong. This constitution was filed in 2013.
Any interim order?
No, there is
Then what happened? If interim order might have been closed in a FR or a search sheet, you have the instruction, and otherwise there was a civil dispute.
only initial that the page 15 in the FIR. It can be crossed or because the
What happened to the civil suit? What happened to the civil suit?
civil suit.
Yes,
So there is no civil.
there is a civil suit, I think, for cancellation of the sale deed.
No.
Huh?
Case is with lordship, at the.
Oh, no, not, this is not the case. That is other case.
Purchase of the Pata land lordship, I swear an affidavit which is required for obtaining printing.
This is a case of absolute quashing.
I will get the.
This is a case of quashing. He has declared, he made an section 10. What was the offenses registered, Mr. 182. 182 is not applicable here.
It is non-cognizable.
Not even if think that, because he has at a time of purchase, this is not a case. You have an instruction of two. We are quashing this. See, this is a 2013 matter. That's why you have specifically instructed that there should be a separate cases of quashment. Will maybe in orders, maybe hearing, it will come in the quashment. These cases are pending since 2013. This is a case for quashing. Whatsoever this, that is not the issue of the deputy commissioner. That may be some different process. There cannot be any criminal offense. He purchased the land. And what is the allegation? See what is the, and what of affidavit regarding what? Where is the affair? So he said that I will use for agricultural purposes. Now he has used it for industrial purposes. What is the criminal offense? He has not filed any false affidavit. He said I will use. He has done is something different. Where is the case of 182? Nothing, I do not think anything is proceeded. Okay, when? Give a date.
City on 26th of
Uh-huh.
January, 21st.
38th of August 2020 for instruction to be obtained by Mr. Bhattacharya regarding the status of the criminal case being the FIR is give up, Jalukbari PS station or something like that. Huh?
67.
Sangsari PS
67 of 30.
67 of 13 under section 182 IPC. Yes.
Item 29 to 33.
Yes. Vijay Senior.
Item 34.
Yes, Bhattacharya.
Yes, madam, today, madam, after some time, I'll get the report.
Then we are adjourning it. Mr. Sharma, tell us, will that specific notes, cash amounts will be required subsequently? Suppose we allow you to circulate. You circulate it, that money will never be back. Suppose it is required during investigation. What is the proposition of law in this regard?
The internal judgment
Hmm.
that this may take the photocopy and the magistrate may take evidence. There is a procedure. After following of the procedure.
So that procedure will start magistrate in view of the division bench judgment after filing of the search sheet. Search sheet is not yet filed. Search sheet is not yet filed. So I was thinking today. So we are fixing it on 1st of September.
And
No.
my instruction, police has already, madam, handed over all those.
No, Jimma is given to them. What is their prayer is, let's see, this money belongs to us. This was, somebody attempted to take it away. But somehow it was protected. So the money possession was handed over to us. There is no dispute that this cash belongs to us. It's a bank, financial institution. They say, instead of keeping it in a trunk in our bank, why should we not circulate this amount? That will give an economic boost. Our idea is, yes, that can be done. What is the fault from that? Money belongs to them. Now the question comes, will that notes will be required during the period that this was the note which was seized? This was the trunk, it was seized, so therefore exhibited. If that be so, what will happen on first? Why? What is the problem on first? We fix other matters on first. No, we have fixed it on first. We are fixing it on first. If you are not there, also we'll think over it. Okay, on first. Because the whatever has fixed other cases on first of September. Think over it.
Yes, sir, I'll do research on.
You do there, because even if under 457, in view of division bench, court can give it. No problem. 482, we can also give it. But the implications. A vehicle can be taken back, yes, but this cash amount will not come back.
It will not come.
It will not come back.
Because it is quite.
It will be circulated. Think over it and address us.
Item 35. Postman.
Please, these are not, possibly kindly pass up the timing of the needs and therefore.
Difficult. Every matter is being time over. And I am a division bench, having a division bench at 3:30. Okay?
36, next.
Yes, Bhattakur, we require the 161 statement. See, both lost to affairs. Both are doctors, they are having relations, and now 370 cases recorded. I do not think this is a case of 370. So the scan copy of PRC case number 180/2022 corresponding to GR case number 2466 of 2021 has been received from the Court of Judicial Magistrate First Class Dibrugarh. However, the case diary and 161 statements are not available with record. Accordingly, registry to obtain the case diary of, what is the police station case number? Case diary. Scan copies of the case diary of Dibrugarh PS case number 1247/2021 under section 406/376/384 IPC. List this matter after 3 weeks. Interim order pass earlier, shall continue.
37,
37 is the supervisor.
Okay, fast, 19. This is on 1st of September.
38,
Yes, Ahmed, what is this? Hmm. Then,
I am regularly paying some maintenance till today. Since 1989. After more than 30 years, they still file a case for domestic violence. Whether there is a domestic violence.
then what happened? How
Then
the,
domestic violence is awarded, also awarded monthly relief, and also provided, provide a room, and city, everything. That is why we file also file an appeal. Give the dispute file without providing our case. Now we will also kindly see the water pump by the magistrate.
yes, Ahmed,
They are maintaining that marriage law solemn has wrong there. But if you lordship see the definition of aged person and the definition of domestic violence, their economic abuse is also there. If they do not provide any financial support,
but according to him, he is giving the maintenance.
yes, that is the section 26 is also there. Section 26 says that in addition to Lordship kindly see section 26 of domestic violence act. And only duty is
What is the award in the subsequent DV?
initially lordship she was given to her 2,200 rupees. And subsequently considering the earlier aspect, further it was granted 1,500 rupees.
So
And
total
the-
3,500.
Yeah.
Give a date, we'll hear it. Give a date, we'll hear it.
And the lordship, only prayer is that a short date will be because
Ah.
LCR is here.
So we'll,
Original LCR is here.
was it an interim order?
No, already LCR is there, so there will be no record for that.
I don't say.
For this document.
Give a date, we'll hear it the matter.
Next,
Musumi,
Pilot is located in Chowdhury.
18th of September.
Admission.
Admission here.
Okay, then, I am already regularly paying.
Now you pay 1,500 more, you pay till 18th.
That may work. 1,500,
No, if whatever you are paying, we are not passing any interim order today. We are deciding the matter on 18th. Okay, today is 1 month you wait,
Only by the.
24th of September, 24th of September.
Only I.
Today, Mr. Don't insist today. We'll have to pass the same order dealing with the interim. So we are hearing this matter on 18th of September. 18th of September. Then on that date, we'll decide the matter. We'll decide on that matter. Be ready for hearing. We'll decide it.
For the winning, is there salary? Is there amount? Is there amount? I will pay regularly. Only 80,000 is there amount. Definitely.
Give some. Give
I
some.
am paying. I am in this one. I always.
You are paying the board.
My lord.
Area for which period? Tell us.
Okay, there I paid my lord. 82,000 now court ordered me to pay 6,500 per month in addition to one.
Okay.
I am paying my lord. I am paying my lord. That amount I am paying. Now I am.
You are paying the 6,500 also.
Yes, that is the bad.
So pay it. This is for 1 month only. If you are paying, pay for 1 month. On 24th, we will decide it.
Because they have not paid maintenance, therefore DBK was filed in the.
No. We'll hear it on 24th. Yes, Mr. Ahmed, we'll hear you on 24th. We'll give you a patient hearing. No, Mr. Ahmed, Mr. Board, keep your energy for 24th or 18th. 18th. On 18th, you come with full energy. Don't waste the energy unnecessarily. Yes.
39 and 40.
Make you the lord. I pay for all accommodation lordship. Next week, getting the subject to condition lordship.
Your wife,
No. Lordship, I pray lordship, I try to satisfy lordship because if one case FR has been given lordship. So lordship,
you first lost the affair.
no lordship,
She lost the affair.
no, I find friend.
Huh?
But I have submitted one affidavit, my lord, really.
No, just tell us. It is an interesting story. What happened? You want an accommodation to do.
Lordship,
Just remind us,
lordship.
you are the wife or husband.
No, I am the lordship.
You are the other man.
He my lord kidnapped my king.
Just tell me.
Lordship in one first case.
You are, according to him, you kidnap his wife
Lordship,
and child. And your wife says, yes, no, he tortures me. So I have left him and I married you. So you quash the affair.
Lordship. There are two FIRs are there.
One is by
My husband and she also. Later, my lord, my wife also filed one FIR against me. Complaint case.
why should we believe her? Why should we believe her?
Yes. Once it is,
This is absolute abuse of the process. When tell us.
lordship, please tell next.
No, that cannot be. You will take an adjournment Tuesday. We have fixed many other matters. The moment court expresses its view, you want it on Tuesday. Yes, when? September. 19th of September.
Lordship, I have no problem, lordship, I have half the blood.
We are already satisfied.
Lordship.
He will have to satisfy us.
Yes, sir.
Item 41.
Okay.
As 19th. As agreed to by the Learned Council of Court. Then I will clear. Yes, Ahmed, what is this?
There is no mechanism to show that they were jointly carrying those items. Because of the commercial company lordship, I am saying.
Here, 10 copy was also. What is
Scan copies of the case diary as well as records of special and DPS case. Okay, the scan copies of the case diary along with the case record call from the learned special judge Karimjan's it is only on 7/8. That's why has not yet received registry to issue reminder and list this matter. Give a date in the month of October.
The month of September.
September, month of September. 25th of September.
42,
Part of the time.
Your whole case is the CA report.
Yes. I have been put before the blame.
No case. Where is Mr. Kamar? Not today. Because you are having a DB at 3:30. Many matters are made timely. Okay, timely.
item 60 of supplementary list.
That is right.
Yes,
Document representing for number 2.
you are appearing for, what is this? Criminal petition. Quashing.
Yes, sir.
What to be quashed? FIR.
Yes, sir. FI is the page 15. There is a
Yes. Now petitioner is not there.
on the previous year also, they have submitted for a hearing. And this on the face of the FI, it's a process, final 50 establishments are formidable offense. Yes.
Non appears for the petitioner on call. That's why we are vacating them. Non appears. Non appears for the petitioner on call. Accordingly, the interim order staying the investigation of Kokrajhar Police Station case number 29 of 2021 by this court under its order dated 10/3/2021 stands vacated. The case diary be returned back to the investigating officer, and the investigating officer shall continue with the investigation. List this matter after 6 weeks. We have vacated the interim order, directed the case diary to be returned.
Taking matter once again. I was under the belief that we should continue the other matters and the additional matter was taken up. We have the precedence goes on in this.
This is under cross-mission. So we have separated this crossment to a different, because many things are mixed up in admission. So all crossment will come either in order or hearing whatsoever under this head, and we'll try to decide. So ready for final disclosure?
I'm ready for the final discussion otherwise. Yes, sir, 420, 460.
Basically, your argument will be that this is a lending of
Money.
money, and where is the initial reception and where is the interest? That this will be your case. What is your answer?
Apparently from the face of the record, it is apparent, there's no. inducement
Nothing, no inducement,
on
nothing.
my part. It's not from the fixed FI itself, it's simultaneously reveals docket of the communicable offense. In the FI also, it's clearly stated that we have taken money.
Mr. Bora's argument will be that you have given 55 lakhs to a person with a condition that you will return it.
And I was in a hardship.
As you are in a hardship, you will return it. Now, he has not returned it. You call him over phone, then he refused to reply to you. Then you call him in WhatsApp. Then he said, okay, I will give you. Then subsequently he stopped calling you. Therefore, according to you, you have cheated. What are the ingredients of cheating? If you want some time, we can give you. There is a fine line between a civil case and a criminal. You will have to bring out that fine line. There are some recent judgments.
Apparently,
Otherwise, we are in favor of passing this.
it is absolutely no.
He's a young counsel. You are a stalwart in the other side.
Also, kindly to the kind of, and even in this FIR also.
If you want to argue, you can continue. I have no problem.
the given of time for hearing.
What is the ingredients of 406 and 420? Whether anything is disclosed in the FIR. That is the issue. On just simple reading of the FIR, whether case is made out. That much. And we'll hear first the public prosecutor. Then we'll hear you. According to us, reading of the FIR, no case is made out. So you may say that FIR is not the encyclopedia. Investigation should carry on. You may rely on judgment of Niharika. That during investigation, there may be something which may come out that his initial deception was there in his mind. That may be your argument.
And the expectation is in
So, give a date. You are a young counsel, argue properly. But our view, when? No, give a date. You will need preparation. I am ready. Mr. Bora is ready. Give a date. 22nd of September.
that it will be kept part-time and
We have not heard yet.
hardly of everything, madam. It
Yes.
has already expressed the mind of the.
This is a tentative view reading of the FIR.
View, but-
I have said both ways.
Yes, that's what I'm saying, saving the 44 time in future.
Okay, 22nd, it will come back. Not necessary to be further, it will come back here.
I'm not
Till-
because of, I'm
Till,
not hunting the bench, rather I'm saving the time of people.
so it will be here till puja, I think.
Puja will come, thereafter the last thing will come.
Yes,
It will come after the puja.
this better. It's better.
Not always better, but
It's better.
depending on the person to person, where people.
No, it's better.
Very well.
It should come after puja. It's always better. If something you can, if you can bring something Moharam or maybe Kati Bihu in between, it's harder better.
So, you can admit it and
So we'll decide it. That's why you have made in the crossing thing. We'll decide it. This will take not much time. Law is well settled. We'll just have to fit in the formula. On 22nd, be ready.
61,
interim will continue.
Interim order pass earlier.
Secretary interim should continue.
Yes.
Okay.
61,
Yes. Petitioner. Yes, Borua.
Custodian is not the grateful employee.
Uh-huh.
Here is allegation of grateful temporary employee that yes, misuse of misappropriate some excess amount, which is transferred the account of treasury officer to account of some employee,
Hmm.
that employee.
Hmm.
It's the grateful employee.
Hmm.
And now allegation against him that from the grateful employee, here are check was issued and he withdrawn the money from the accounts of the grateful employee. But amounts is transferred from office account to the employee's account. And the custodian of this whole accounts is the treasury officer. Treasury officer is the king as some, there the apps, he is the password, he can transfer it. A grateful employee cannot transfer it. Now this grateful employee was.
FIR is at page
Page one,
30.
30, yes. And 33 is the FIR, page.
That is the letter.
Well, kindly first see the letter, man, and accept the page 30. The meeting is the grateful employee. The numbers of leaves have been found and credited in Manglam's name. So he has no AC number so and so. Everything this account has statement of Manglam's name, it is found that on 2/7/2021, an amount of 197 be and withdrawn to you. So the other checks this and that too they are silent. Who withdraw? And then other amount might not receive. They have no idea who is withdrawn, just implicated in the other amount.
Just give me a minute to read this this letter.
This not for example, insert the directory.
What is this mortgage?
I'm not, other thing I not. In August, it was, because referring to this, it is not that this is again. And they took 83 days to file the FIR. It is because they under the, this, he was put under person, that you will be put into jail, otherwise you will never submission of it. Then compelling circumstances, he mortgaged land. And he paid all the amount, because it is small person without regular.
Let there be investigation. How allegations are specific. How can you quash this affair? Investigation will reveal that you are not involved.
Because according to that, there are some other people.
You are representing whom?
There's no other information.
Other understood. So PNP wants to take the custodian, and he has received.
Can we decide all these things? Because there is a specific allegation that through a sake, bearer sake, you have withdrawn. Who has withdrawn, how withdrawn? These are a matter of investigation.
Not from all this office accounts, my lord, this accounts of someone else.
Can these facts be decided in 482? Answer me that first.
Or whether
What are the grounds to quash an affair?
cheating elements or producing can evolve from this. And whether it is a
May not be cheating, may not be 406, maybe some other offense after investigation. There may be a final report after investigation.
they should come with the details report and whatever who, and this is Mangalore, is a beneficiary, he is not doing any, he is not implicated, my lord, how can it be?
He is not implicated in the FIR. He may be implicated during the investigation. That this man is also involved. The treasury officer might be implicated in this thing.
Treasury officer has knowledge that this is going on, and still he is not doing anything, he take a leave, and it's just treasury officer file the FIR after like 3 days.
Understand? So the person who was on leave, he might be an accused during the investigation. There may be a final report in your favor. Can we decide all these things? Are we the prima facie case of cheating is made out?
But he is not custodian. He is not custodian, how can he receive? Someone else.
Transaction, the data for transaction in his account details are showing account.
And
amount that he transacted.
And his accounts also not amounts is.
He has taken out the amount, then he later on without.
Is there any stay?
No, my.
Yes, whatever. What is the status of investigation? Okay. The present application is filed for quashing an FIR dated FIR FIR in connection with Kozai Police Case number 690 of 2021 dated 11/10/2021 under section 420, 406 and 409 IPC. Full stop. The learned public prosecutor submits that he is not aware of the present status of the investigation, inasmuch as there was no interim order staying the further investigation. In that view of the matter, let this matter be fixed on 19th of September 2023. Full stop. On 1923, on which date the learned additional public prosecutor shall produce the status report of the investigation, and if the investigation is not yet completed, shall produce the case diary. Full stop. List this matter on accordingly.
Timing matters, I think 29 to 33.
You are good. Who is for the respondents? Any name shown?
We have done that.
Yes,
Yes, I've done that.
yes, you are here only. No meaning of listing these cases.
I think 35.
Yes.
But my prayer is, passing of the charges, vis-a-vis the, order of issuing, taking cognizance and issuing process so far as the present petitioner is concerned.
Where is the FIR first?
FIR, my lordship, will find it page 22. Married.
Sick. Yes, madam.
Your lordship, there is another thing.
I am rising. When the seniors will be free, please inform us.
My lord, please, madam, the, main party is the public prosecutor. Is being informed.
That's
So,
true.
limited
Yes,
time.
Bothakur, they said that we have supplied amount, he has not paid 138, this checks are there, we reserve our right to, file case under negotiable instrument act. It's a business transaction, how can it be a,
This particular case, my lord, the entire kind of transaction is different, my lord. The entire transaction took place between the informant and Mr. Pannadev. I am not Pannadev, my lord. I am Pinak Pani Roy, my lord. And I had certain business dealings with Pannadev, my lord. He issued checks to the informant as well as I am also one of the trader, my lord. My check got encased, my lord, and the check of the informant got, my lord, dishonored. And that is why the charge sheet has been filed against me also, my lord, in this particular case. Implicated for nothing, my lord. I will take a vote for it after.
yes, you go through it. Anything, you just go through it. Call us when people are free to argue.
I may come from.
Busy with councils, all are busy councils. When it is difficult, when we were in practice, we did not have any difficulty because we did not have that much of cases like you. Yes. Okay, let us start it. At least something we can hear. Yes. From morning, nothing is happening except bail. Yes. Bail will be there, but yes,
So, my lord, as your lordship,
we are going for disposal. We are going for final disposal. But either we will have to give an in
to be honest, my lord, I have come later for prima facie.
motion stage. Motion stage is in.
I have to go for hearing the judgment and all.
Suppose you have come for motion stage. Motion stage, what is your
My
expectation?
prima facie are satisfied that there are matters to issue notice and for things.
Stay. My idea is this kind of cases, it should be decided at the motion stage itself. No, either we cross it or we dismiss it.
I am.
And we are having a very bad experiences, all in all crossing matters, notice and stay, and this nothing happens the final year. So certain matters we have decided either will not go beyond motion, and some other matters which will not go beyond admission.
Admission we understand, because that time we get a chance to argue the whole matter.
So that's why we have fixed it on Thursday so that we can decide it.
But I took it as a motion stage just to prima
See, Mr. Kumar, suppose you argue on a motion stage. If I give you an interim order, I will have to give the reasons. Finally, it revolves around whether prima facie case is made out or not. Is that it? And if I decide also, or if I reject also, then also I have to give you a reason.
reasons is always there.
Reason is required. And those reasons are the reasons for final disposal.
That way, my lord, to be honest, I am not prepared for the full stage of hearing, to be honest. I have only prepared to the so I would like to
But this court, we have fixed it on Thursday because that we can decide this matter.
That impression I didn't got it from the last time. I thought most of the time it would be that. If I'm not mistaken.
So better let us have it any other day, next Tuesday. We'll decide it at this stage itself, next week. Be prepared, we will decide itself.
And up next week.
Mushmi. No? 31st.
But 31st my last. It is like, yeah.
First we cannot, first is some other method, Jimma and all are fixed.
Then on few minor people, you know, they go from learning.
From second onwards, there are holidays.
Yes. September to 6th. But I am not available for.
What judgments you require, Mr. Kamar?
Well, I think there's everything, madam, because nowadays, this one is also one competition, and everything is being one.
But
So
for
we
that,
have to play the operating budget. Now we have got to take a final for them. A lot of people got it very correctly. Our term is the CAC. And that is the prosecution document of mine. Reserve is the other documents we have added. So I have to show everything to the logic. So these are all official documents, not my documents. And that CS report is the ultimate report that we in the whole case of it. As my level is very correctly said that before the charge sheet minor, this report was in existence, but they have not put that. They have taken the part of the back.
suppose we take the CA report to be absolutely correct things.
Yes.
What it says?
It says
That orders were issued in your favor. You purchased it, you have road permits from Haryana to this, that, and that. There is no quarrel on that. But the basic allegation is that while giving you the order, there were manipulation itself, you are part of a conspiracy. Can that be, CA report be basis to negate this? That is left answer. If you can,
No, your logic will see. Suppose
what the CA report? CA report clearly says, yes, I have examined all bank accounts, everything. Order were placed. He purchased it from such and such place. It was given, tax was paid, road permit was there, everything is there.
okay.
Transaction is clear. But the question is, according to the FIR, in an escalated price, without some fraudulent mean, in a conspiracy, this was awarded to you in an exorbitant price. If there was a conspiracy, can that be negated on the basis of the CA
Because
report?
of only one thing, suppose something wrong was done officially. Am I responsible for that?
No, you are not responsible. Whether you are responsible or not, that is a different issue.
Absolutely.
Issue is that it is alleged that you are also part of that conspiracy to purchase those things at a higher rate. It's not only the case that order placed, not supplied. There is no issue of non-supply. You have supplied it, but by manipulating.
Whatever the price is given.
Yes, but their allegation is that you are also part of the conspiracy to the execution. How can that be satisfied on the basis of the CA report? If you can say that, yes, CA report give clarification. Yes.
We see that even if the contract was wrong and the work was carried out, no fault is defined.
No quarrel on that.
What is the problem? Question?
No quarrel on that. Quarrel is on that allegation is that 1, 2, 3, and 4, you conspired that tender will be like this. This will be price. These two person will participate even without having the required qualification. Award will be given to you with an exorbitant price, and that is the allegation.
If you're not.
Crores of rupees. Crores.
No, crores of rupees by giving articles. I didn't got it for fun. Lordship of Knighton said that it's not the case that I did not agree with the work. Everything is that. But all the mischievous way the charges have been filed and the FIR has been got. FIR allegation is totally different starting from the first point. So that's why when it, if your lordship is going to dispose of.
We cannot have a mini trial at this stage.
Absolutely, no roaming inquiry. I do agree.
No roving and fishing inquiry, we cannot have a mini trial
That
here.
is what I'm saying. But the basic thing I have to show is that this whole case starts from an FIR,
Hmm.
which itself is faulty, I'll show you. That is what my question. The FIR, the allegation that has been developed doesn't carry with the documents which has been given in the court. So it's completely on a different notice, not on a soft code. That is why I'm saying that it will take some time.
Okay,
Quarter petition, and of course. Now the second thing is that, my lord, my only point is the lordship with this, for the lordship mouth is that my only condition, your lordship wants to say that the tender process first. But the other part is.
no, tender process was wrong also cannot be blame it to on
on a
you.
private person.
But if the allegation is that the tender process was so made with a conspiracy and intention to siphon of public money, then
Absolutely, my lord. But where is that siphoning out? Where is that manipulation? Where is that fraudulency? And on the other hand, my lord.
suppose there is a allegation is that there is a conspiracy to buy an amount thing which cost 50,000 and that has been purchased at 1
Where
crore.
is that making?
We'll see that, but therefore we are saying that the
Then there is no material to that, my lord. That's why we are coming, because once we file a question, my lord, we have to be alert, my lord. Then all is on record, we cannot add anything, we cannot subtract.
now tell us the date.
Your lordship will kindly, because we have not some issue with the party. September details. After 9.
Because Kamar is now plays two roles and two roles. Sometimes she'll have to go outside to play other roles.
Well, there's a part of the royal right. Wherever the honey goes.
Yes.
Everybody is correct.
Isn't it? But that
And
part,
that experience
for-
your lordship also has.
for that part, we'll adjourn the case. For that part, we'll adjourn the case. On that ground, that is a genuine ground.
Okay.
Yes.
Now, more people. More people.
15.
15.
Mr. Kamar, we are open. We have not
No, no,
taken
but
anything.
I don't- I can't-
We are
That
open
one
to
we
all
don't
this.
want to- Only thing is that I would like to show. Now, everything I have to show line by line. That's why we take some time, but then we will do in the second part of that.
And we'll decide on that. Not, in this case, no interim, nothing of, either,
That's it. Then-
either you are,
Then only come to you. to that.
when?
15th.
15th of September. As agreed to by the council for the parties, leave this matter on 15th of September. Yes.
But just before party, they say in this case, my lord, that I didn't have the license to also appeal maintenance. The subsequent income, everything is there, but in the charge sheet, they have written that I don't have what is the license. So that's why I have to enclose the license of government. So this way the charge sheet was complete by. And evening time, locally, only 10 copies. Charge sheet has been required.
10 copies.
10 copies.
Okay, in the meantime, registry shall obtain the scan copies of
Charge sheet. Charge sheet and 207 documents.
the three search sheet in connection with the CM's SBC PS case number 9/2017 dated 7/11/2017 corresponding to special case number 9 of 2021 and the
And the 207 supply.
and the scan copies of the
Copies of the.
documents supplied under section 207 CRPC.
Now the stage is my supplying. Market. Market. And sorry for doubling of the time.
I think 35.
You are Pinak Mani. I thought you were that other man.
No, no, my lord.
Where is the affair?
Against this person, I had also logged an FIR.
Where is the other lady gone? Respondent number 2.
Peanut paneer oil, no? Charge sheet submitted against Annadel and Peanut paneer oil.
Panna Dev was the person.
My lord,
Okay.
is it prime minister?
Statement of peanut paneer oil is also available.
We're crossing it.
I just take it point of view.
See, what is the case of the just then you answer me. What is the case? Case is that this, what is your name?
Peanut paneer oil.
Pinakpani Roy is having a house, a godown at Poltar Bazar. That was rented out to Panna Dev. And there was a supply dealings from your record, supply dealings between Panna and Pinak. Accordingly, Pinak, you are Pinak?
Yes.
Panna issued a check to Pinak, and which was honored. He also said, yes, this check was given by his employee so and so against house rent and against supply of rods and something. Okay, this is the statement. We'll go by the statement, nothing else. Then the FIR lost by whom? By her client. What is the name of your client?
Bhushan Kumar Joanna.
Hussain Kumar. Hussain Kumar says, not against him, not against him. There is no allegation against him. Hussain says, Panna supplied this much of amount. I have supplied this much of grocery to Panna. Panna was supposed to give me. He has given me check under section 1 check. However, these checks are bounced. So therefore, it's a sitting case.
Madam, I just like to further your lordship.
And the search sheet says this is a case of cheat. In fact, for the timing we are not on him, but what is we suspect that he might be also involved. That is can that be a ground to file a charge sheet?
FIR is laws on 27/10/21.
Yes.
And when amount of rupees 65 lakhs transferred by us on 27/10/21.
Maybe what is the link between,
Yes. So, police suspected that amount is who.
can on the basis of only suspect a charge sheet be filed?
That is in the search sheet, in the investigation, it is not clear,
No, what not clear? Everything is, statements are recorded.
But he has stated that he is the landlord. But in the record, in the petition only the copy of the agreement and everything is available only in the petition. But in the
It is you have not seized it. You have taken his statement, you ought to have seized it. Yes, madam, what you want to say? What is his grievance against him? Forget about the other.
I received the money that I need to get.
Huh? Yes, tell us. You are not aware of the facts. Nowadays, be aware of the facts. Forget about the seniors. From tomorrow onwards, forget about the seniors. Don't come to mention for adjournment. Come with the brief, we'll help you. Where is your brief? Who is your senior? B? Where is he?
CBI. It's a very vital matter.
He is in CBI for a vital matter and not before High Court. Hard. Mr. Swenso, learned counsel for the petitioner. Also have Mr. Bothapur, learned counsel, additional public prosecutor. And also had MS P. Borua for the respondent number 2. The present application is filed. Present application is filed under section 482 of the Code of Criminal Procedure 1973 for setting aside and quashing the charge sheet being CS number 137/2021 dated 20/12/2021 and order dated 24/12/2021 passed in connection with PR case number 3077/2021, whereby the learned who took the cognizance? Whereby learned Court of SDGM to Kamrup Metro framed charges under section 4 to cognizance of under section 420/406 of the Indian Penal Code against the petitioner and another person, namely Panna Dev. Full stop. Panna Dev. Full stop. The scanned copies of the LCR as well as the case diary has been produced and perused by this court. The prosecution was launched on the basis of an FIR by one. What is the FIR? Page
22.
By one Bhushan Kumar Jain, proprietor Khang and Sons, before the SCP Panbazar, inter alia alleging that one Mr. Panna Dev, owner of Shiva Ganesh Traders, Sima Plaza, 4th floor, Ulubari, Guwahati, and a permanent resident of Silchar, was having business relations with so many people around Guwahati, since last 3-4 months, and the informant has come to know that he is a fraud and defrauded many business concerns, including the firm of the informant. According to the informant, defrauded the informant to the tune of rupees 135,78,188. In terms of the aforesaid FIR, and according to the informant, the said accused has removed the signboard of his business firm and since keeping his residential and official addresses as well as mobile numbers. It was further alleged that it was also stated in the FIR that the informant reserves his right to invoke Section 138 of the NI Act in due course of time. Full stop. After the investigation, the investigating officer submitted charge sheet, which is under challenge in this proceeding. And in the charge sheet, the present petitioner, though was not named in the FIR, was charged as accused and was sent for trial. Full stop. The case diary reveals that the statement of the present petitioner was recorded, as well as the statement of the present petitioner was recorded by the investigating authority. The petitioner, before the investigating authority, stated that he is the proprietor of one Messrs. Turn Construction or something like that. Huh? What is the spelling? AET RAY. Atre Construction, Paltan Bazar. And he knows the prime accused, the accused name in the FIR, that is Panna Dev, since August 2019. Okay. Atreum. Atreum. Full stop. He also stated that he is having business relation with the firm of Panna Dev, and he has also given on rent his godown to the said Panna Dev. He further stated before the investigating officer that a check the three numbers of checks totaling an amount of rupees 6,50,000 or what? 65 lakhs were given to him in connection with the rent of Godam as well as certain supply of rods, etc., made by him to the aforesaid Panna Dev, the accused in the connected police station case. Full stop. The petitioner has also annexed an agreement, rent agreement, along with the present petition. Agreement as well as the purchase order. The case diary further reveals that the petitioner, the petitioner has been arraigned as accused only on the ground that the investigating authority suspects that the present petitioner might be involved with the prime accused Panna Dev, for the reason that the check issued in respect of the present petitioner was honored, whereas check issued in respect of other persons were dishonored. Full stop. Except the aforesaid honor of check issued by the prime accused in favor of the petitioner, no material is available on record to make out any case or involvement of the present petitioner under section 406/420 and this the 420 of the case. The law is by now well settled. The paragraph from the other common judgment. What is 405? What is 419? From the aforesaid, it is absolutely clear that no case against the petitioner is made out, and the learned trial court, while taking cognizance, has failed to apply its mind to the material available on record, and accordingly, this court is of the view that no case is made out against the present petitioner to proceed in the case. Accordingly, the present revision petition stands allowed by setting aside the order of cognizance dated so and so against the petitioner and petitioner. Please. Okay. It is, however, it is made clear that this court has not commented anything against. This should not be treated as any. The present order shall not be treated as anything on merit, on connecting and involving the prime accused Panna Dev, as he has not preferred any application before this court, and he is not before this court. Full stop. Accordingly, the proceeding that will end there. That's all. Okay. Accordingly, the proceeding is set aside and quashed. So far, the same relates to the present petitioner only. Nothing is there. Nothing is there. And see the investigation. Statement of him only, no other statement. And what is the information? He has cited somebody in Arunachal. So I will be vigilant to arrest him, and that's all.
Was kept sitting there in the police station 3 long days, I have to get bail from this atmosphere. I have given entire transaction, black and white, bank transaction, nothing.
For admission, item number 8.
Not necessary, we have passed it.
8, 9, or 1,
19. Jima,
8, 9, and 10.
8, 9, and 10. Jima, on 1st of September. On that date, we will dispose of the individual cases where we can exercise our power under 482. And in the cases where state preferred an appeal, there we will deliberate on the other issue. In other cases, we'll go case by case. And even if it can be given under 482 without reference to the division bench or others, we'll allow it.
My lord, Item number 6, when it was called for, it was absent.
So you are absent.
That was already big, but my heart of is the item level. Let me give on one level.
If you are absent, we have passed an order.
My humble,
And our thing is that when I take a break at 11:45, almost 12:15, maybe more orders I have already signed. This might have already been. So for this 5 minutes or so, we sign orders. Okay, we'll see. We'll see.
on my side.
We'll see that if possible. We cannot commit anything. If already signed and made online, we cannot change it. Yes, next case. Amke Chaudhary ke Mata will decide this.
Standing item number 29 to 33.
This is the third time. And this is a matter pending since 2021. Any interim order?
Yes, sir. In all the cases, my lord, since 12th of March 2021, the interim order is.
What happened to the civil suit?
Civil suit another. But otherwise, there are person that there are what they have challenged is that because of the pendency of the civil suit, this criminal proceedings are not. So there are judgments of the Honorable Supreme Court. In fact, one of the allegations which has been leveled in this complaint, and I will find that there are serious allegations, even against the public. Sorry.
According to you, you were not even present in
Absolutely.
executing the
I was
cell.
not even present. In fact, apparently from the cell lead, if you lordship find, there are spaces in the cell lead where my signatures are not. And the cell lead is yours. I have made specific allegations against the sub-registrar, the,
I've seen that. Specific allegations are that you have never executed.
I have the.
Now, how can we deal with this in a revision petition? That no, it was his signature.
Yes.
There may be civil suit.
Yeah,
You may seek with this declaration.
Dispute.
The civil suit is filed for cancellation.
Cancel it.
That is a different issue.
Because the remedy that is available in the civil case only for.
And cancellation is also on the ground that this is not been executed by
Never been.
executed. So FIR investigation will have to continue. In this case, even that will help the civil suit.
Yes.
There will be evidence of forensic
For
and
both
signatures
For both sides.
for both sides. So you are dismissing your revision petitions. There is no possibility of it. How many lawyers' names are shown? Be prepared to argue before this court. We do not know seniors and juniors. We cannot. And today is I think the worst day. Every cases are being adjourned on the ground of senior.
I may point out another lordship finds the order sheet.
Hmm.
Despite there is a stay order of several accounts adjournments. And the investigation, the complaint proceedings, everything is.
What is the FIR? Why have you filed again complaint cases?
In,
Either an FIR investigation.
there are the complainant and the informant, there are two set of allegations.
Hmm.
One, in criminal petition number 152,
Hmm.
his allegation is that his photograph, his signature has been used for obtaining the cell phone.
Hmm.
Apart from the other allegations which are from arising out of the same case. Sorry.
Father and son duo is the informant.
Yes.
And what is the FIR? FIR says that this cell deed is never been executed by me.
Yes.
This is not my signature.
Right.
So if we go through the FIR, a case is made out.
Right.
This will be your argument.
Right.
Their argument will be that no, this is an abuse of the process. They have sold us. These are the facts. These are the figures. This will be their case. And your case will be no. Therefore, I have filed even a civil suit for cancellation of the sale deed. That we understand. Why the complaint cases?
My lord. I just point out one. If your lordship finds 152 criminal petition, 152 and 156
Three criminal petitions are there. One is for quashing
of
FIR.
FIR and the rest are for the complaint.
complaint.
152 criminal petition, 152 and 156. There are different allegations by different complaints. One, the nephew of the seller,
Hmm.
he says my photographs, my signatures have been counterfeited, forged, and they have taken the sale permission from the authority.
Hmm.
That is the
For
separate-
the purpose of sale permission.
for the purpose of sale. In 156 covers the subject matter of 156 this. Now regarding criminal petition 154 and 157, allegations are same.
That item number 1 is going on in court number 1.
So 154, 157, this takes care, well, this is complainants are same. What happened? FIR was lodged, it was not registered.
Hmm.
By that time, they have filed a complaint.
Hmm.
Subsequently, the FIR got registered.
So that part, that
So that this
complaint will go.
that 154, 157, section 210 of CRPC matter takes care of that. The magistrate can call for a report from the police, and if the charge sheet or the investigation is done in the FIR, then the complaint will be seen and it will proceed with the FIR. So 154, 157 can.
But what to do? See his sorry face.
And
When? Hmm? Your signal is out of station. Mostly when can it be done? 7th of September. 7th of September. 7th. The matter stands adjourned on the prayer of learned counsel for the petitioner and be listed on 7th September. No further adjournment shall be granted on that
I
date.
For hearing item 53,
in fact, two criminal petition on the I was thinking of considering, but that can be taken care of because this allegation takes far.
Yes, that's why I'm asking.
That
That can be closed.
I'll proceed with.
Interim order passed out shall continue till the next day.
I will.
So list is over. India में others are over. Hmm.
This my lord, everybody is not agreeable. I think of this. So last order of this honorable was passed to engage the legal counsel. Let the into the case of conviction or acquittal.
What is 17 matters are given for hearing, whereas we are 2009, 8 matters are there. List this matter in the part 2 hearing list in its own course.
item 45,
Yes, what is this?
So the criminal legal, I guess, that's one of the continuous. Which, my. Complete
2007.
What do you do?
I work in a box. My income is around 15,000. After my divorce, now I have again remarried. I have a son. I have other family which is to give up from him. And
If
one-
you do a job in a guest house,
small time boss,
understand the laws. You are having a responsibility of paying to your daughter.
yes,
Again, you will marry, you will have the second child. So you bear it.
yes, I have responsibility. It's now 16 years old.
Is he paying?
Yes, I'm paying it, but by the interim order, this order to the director me to pay 4,500. Since then, I've been paying 4,500.
What is the awarded amount?
7,000. It was an enhanced from 3,000. 5 years record. And one more thing, I may point out, they have filed an application for the, but they have kept certain things blank.
Where is your affidavit?
My activity is, they have filed it. The rest of others.
Whose affidavit is this? Enclosure 1. Dipti Rani Das.
This was my string word. Forty eight dollars maintenance probably about 11 lakhs already. That's on 125 months. She doesn't claim, doesn't have any claim, that is clear from the government. So it is full in time. Probably for the government. 4,500 is very legal and of course. Nowadays it's interest rate is rising day by day. 5 days like the share over. And suffering and still studying. So even I have a son, I have also. Expenses. He's the best opportunity for his own operators.
So you don't have any income.
I don't have it.
How are you paying the rent, total cost rent of 8,000?
The same doing is private tuitions.
But you have not declared that.
Statement is blank measure. There is a declaration in the document.
No, disclose even the independent source of income of the dependents, including interest on asset, pension, tax. No.
So can you come to their affidavit page 56, clause F9. Where it is mandatory for the furnish copies of bank statement of all accounts for the last 3 years. He has kept it blank. And there is a serious consequence to the declaration as admitted by the Honorable Supreme Court. Page 60, may I read the declaration? I declare that I have made a full and accurate disclosure of my income.
Which page 56?
56 is of their affidavit. 16/6/2023.
I have seen asset and immovable, self-declared property nil,
Yes.
nil.
9, clause 9,
Clause-
F9.
That you have F,
F9, the F is heading details of.
R9. furnish copies of bank statement of all accounts. You don't have any bank statement.
There is no furnished statement on it. He doesn't have any bank.
So make a statement.
No, I have been paying her this maintenance amount of the daughter. I have been paying to her bank, and through check I am paying. She has lied before this one. Yesterday, I'm the opposite party and family court process. She said that they are not regularly paying because they have paid in advance, excessive amount. They're not getting 4,500 as a regular. Wrong.
No, you file an affidavit that she is not paying 4,500 and you're best to give your
Yes, yes.
statement. File an
There's
affidavit.
no file.
Because you are saying 8,000 is your rent. We want to know from what source you are paying. 8,000 is rent, then tuition fee, then send something fee. All you are giving, he is giving only 4,500. So if you can satisfy us, why will vacate the stay order? So give us that chance.
Everything is before your hospital.
No, not everything is not before us.
Okay, I have to just look up. I will take the expenses.
No, you have, there are expenses. What is your expenses per month?
How much is it? 250. Really good. Tuition,
Where is that? Where is that statement? Where is the statement in the affidavit? This form has been given so that we can come to a just decision. If you are in need, why we 7,000 according to us, we will say that no, we will vacate the stay order, you continue to pay. And if we find that no, you are already having this much of, and your children's requirement is this. So you file a detailed affidavit. Where have you stated that you are getting it by doing tuition? Where is in your affidavit? No, these we cannot look into. We'll have to give by the affidavit file. According to you, expenses of your child is, we do not think this is too much. You have rightly said 8,830 school fee, private tutorial 5,000, tuition fee 6,000, bus fare 3,000, food and medicine 5,000, clothing and books 10,000. Now you are getting only how much? 4,500. You are saying you have no income. You stayed there. You stayed there to come into a conclusion. And where is your affidavit?
My all the bank statements, including the 4,500 they are paying to our bank.
Where?
My statement of the NSF series is 112 onwards.
Yes.
112. I think you know here there are lot of reflections regarding 4,500 in various dates. It is correct. Is 113 $825, 10, 19, 18, 11, 19.
And you are a MA with B.Ed.
Yes, sir.
And what is your graduation?
I have no got any service from the date of report.
We are not happy with your affidavit to give you relief. Even if we want to give you relief, we are not happy with your. Okay. As the affidavit filed by the respondent wife in terms of the decision of the Honorable Apex Court in the case of Neha Rajneesh versus Neha reported in so and so, comma, the learned counsel for the respondent wife grace for and is granted 2 weeks time to file a fresh affidavit declaring the entire facts as required, including the details of the bank statement and any income, any independent income. Not any independent income, comma, if any. So please this matter after 2 weeks.
It may be kept as part-time.
No, we cannot keep all matters as part-time. To give the evidence,
They take it, sir.
give a date.
15th of September.
18th of September.
18th of September. Okay.
You give details here. Be honest. Give details. Then we'll look.
Item 46.
Give it to give it. Give it this. Yes.
By saying order refusal against the petition where allegation of demission is
Order of acquittal.
64.
Defamation.
The criminal division petition was filed, but the court and directed us to file a criminal case. Then we filed this.
One thing I want to point out that after everything field of the they have filed one leave petition lawsuit, but without issuing notice of the he was done. It was
Not that is granted.
really fast.
And the return of the direct character is at page 54. The ground of rejection
Just give me some time because some people are this belongs to a place. So just give me let me see the names first. Okay. Not day after tomorrow. And in fact, 2018 appeal against acquittal, we are not so interested. We are not so interested, Mr. Kaur. Let it go to the part 2. To dismiss.
Only intellectual debate.
So let it be pending. Let it be pending. It will not take much time, but our preference is somewhere else. Today, we passed an order. Matter was listed after 10 years. And going through the matter, it was a jail appeal. My view was then it was a case of acquittal. But after 10 years, it was listed. She was released from the jail, NDPS Act, and no amicus was present. So, moment we take this kind of matter, it is
If you are also not taking adjournment now, mostly this is of 2015, 14, you are not taking adjournment because.
that's why for my list, I have given a new heading, Quasman. Now those will come here, maybe in hearing stage, maybe in order stage, all will come under Quasman.
The ideal way is the matter should be given all matters to the police.
List this matter in the part to hearing list in its own course.
47,
Yes, appeal against acquittal or conviction.
I almost, I pray for sentence of suspension sentence. It is a case of unusual offense.
Where is the paper which you have for?
It has not been provided to us.
I just made a note from the.
Where is the statement of the victim? PW2.
I pray for suspension. 50% sentence is already on.
Let the rest be also over. No case, Mr. Vistas.
That I know, but
If you know that, why should you suspend it? Again, after 5-10 years, you will be put behind.
they can enjoy for 3 days.
This is not a case. Let us dictate this order and dismiss it.
Not today.
Then after at least 5 years, you will be a free man. 5 minutes, it will take 5 minutes. One eyewitness,
No, I know, but I know the better.
one eyewitness, unsecond evidence, the victim, unsecond, nothing is written.
I am not praised for this. Now I got his mother is seriously. That's why.
Mother will face having this kind of son.
Say that we cannot encourage of this. I don't encourage of something the really very satisfactory.
You can decide it. 7 pages judgment.
Next week may come or next month. Let me figure out something. So, if you will free kick, you should say.
Though paper book is prepared, it is stated that same is not furnished to the learned counsel for the appellant and the learned counsel for you have prepared. Okay, learned counsel for the public prosecutor. The copy be furnished to the appellant on payment of cost of Xerox, and a free copy to the learned additional public prosecutor. And list it this matter on September last
28.
28th of September.
58 of this month.
September.
Section 48 and 49.
Yes, what is this? What is this?
Check box case.
You are for the appellant.
versus both are equivalent lots. I issued the check
Hmm,
plus dishonored
hmm,
that punishment and cost was imposed.
Hmm.
We have just for another court to the court. Now, if the relief we have approached the prisoner,
Somehow give the relief to whom?
we,
To you,
what
somehow.
somehow what's it,
Okay.
earlier this, earlier amount was 18 lakhs,
Hmm.
trial court, honorable trial court. Then it is reduced to 13 lakhs,
Hmm,
and punishment was 18 months.
Hmm.
And it is reduced to 3 months.
okay.
Then I have approached the honorable court.
Hmm.
They have also approached the honorable
Because
court,
they want 18 months and 18 lakhs.
18 months and 18. But okay.
Okay, on the prayer of the learned council for the parties, this matter stands adjourned and be listed in the first week of October.
Item 50.
Yes, Mr. Mannan.
That's what I'm for.
Yes, that's what is this
Under the NIT number
negotiable instrument?
138.
Yes,
Right of manner of the petitioner,
an appellate court.
the punishment was reduced.
So they are,
No, I'm not someone. The punishment means they have been given the 4 lakhs.
Hmm.
It was reduced to 3. That is.
you have no idea.
I have not agreed to that. Now, initially also they filed one criminal that was rejected. After the first order of the trial was rejected, then that they have made an appeal to the district. Session court. So
What is the perversity, tell us? Because beyond perversity will not go on it.
Before filing the case of complaint case now, the notice is to be issued
Hmm,
to the person who has issued the check now.
Hmm.
There is no notice was issued to him now. Because they are issued in the name of the company now,
check was issued by whom?
but by the petitioner now,
Debt was due to whom?
by the petitioner, but the notice was issued to the company now.
Where is the check?
Yes,
Where is the complaint petition?
because of the main event my lord.
How it was dealt with by that board of courts, tell us.
Trial court as well as the appellate court dealt with it.
How it was dealt with, tell us.
Right,
First, so this is your first ground, then? Yes, Mr. Tikal, then this is your first ground, then this is the only point. Now tell us how the trial court dealt with this issue. No, it's come to the judgment, how it was dealt with this point. That debt was due to an individual, check was issued in the name of a company.
Right.
How it was dealt, where is the judgment? Page 21. Which paragraph it was dealt?
This is the only main point, only point, my lord. Yes, so the, whether the case will be mentionable.
Para?
Page 25. Okay, page 27. During cross examination, PW1 stated that we have filed this complaint against the Bagorian Associates Private Limited. PW1 further stated in the cross examination that the case was issued by Mr. B. Bagorian Company on 28 to 2008. PW1 stated that it was the accused who delivered the case to him. PW9 stated that the money received of the 2 lakhs was issued by the accused Philip Bagorian. This is another part, the associate private as P. Bagorian and associate private limited one that the notice after the notice are 100 that was issued to company member.
But this check, my lord, this check was not like against any liabilities, my lord, against any debt. It was only bioeconomic grant, this my lord, guarantee. The supplement and his wife made an investment of rupees 2 lakh, my lord, 1 lakh each, my lord, in their business, by the dictionary, which my lord. Against that, they wanted such an surety, my lord, for that, this check was issued. It's just not against any liability, my lord.
Is this related to somehow Bihating tea state? Dibrugarh?
It is Dibrugarh. Dibrugarh.
Some tea related to some tea state, Bagaria family.
No, it is not related to. It is basically individual. The person that the respondent I'm appearing for is actually a manager of the business. Now, at that time he was an assistant. I don't think that is related because he was at that point of time the assistant manager in a, I think,
Because there is a Bagaria Bihating, I think tea
no,
state
that is
near behind the Dibrugarh University.
yeah, but this is not that.
Not related to that.
Only
okay.
the respondent is
Okay, that's at 2.
Right.
Ready?
Paragraph 20
Hmm.
23,
Hmm.
where the court has explained why it has been accepted that the service was notices come. That is in the appellate court also has.
And his argument is that the check was issued by somebody else and
Notice has been issued.
nothing has been issued to somebody else.
But here it was found that the check was issued by Bagaria.
Hmm.
And the notice was received by him. It was received by him, but in the notice, the name written was the company.
Company.
That is the only. And he has also issued the receipt that I have received. That receipt was also exhibited.
And how he is related to that company?
He is the managing director